in part 2 of our segment of how to prosecute a lawsuit. And if you missed segment 1, go back and look at it. We talked about what to do prior to bringing your lawsuit. We talked about the complaint, and we talked about the discovery process that exists in a lawsuit. And today we're going to be talking about phases 4 and 5, which are the mediation phase and then trial if you are unfortunate enough to have to go the distance in your lawsuit. But I want to have Steve Derby again just tell you about his experience and what he does as an attorney and why he does it.
Good morning, good afternoon. Thank you, Amiel, for having me here. Again, I'm Steve Derby. I'm a civil trial attorney with Wade Law Group. I have been practicing law for 33 years, all types of civil cases, everything from family law, all types of civil litigation, employment, disability, discrimination, any sort of case you can think of that's a civil case. I probably have done it at least a few times. What I mostly like about practicing law generally and practicing at Wade Law Group is that I help people. The one constant in all the various things I've done is I've been working for people, not working for big businesses, not working for insurance companies or governments. I've always been working for people. And that's what I really like best about the law and best about working at Wade Law Group and best about my practice for the last 32 years is being able to help people navigate the legal process, whether they're being sued or whether they are suing themselves. And they, either way, the same sort of rules apply and the same sort of procedures get followed. And I'm happy to shepherd them through that process.
Okay. So, and we're always concerned about the finances of our clients, and we know that clients want to get out of a lawsuit as soon as they can. So, and we've talked about points of time in which the case can settle during a lawsuit. So now we're talking about mediation. And I guess the first question I want to ask you, Mr. Derby, is how quickly can a party get to mediation, and what circumstances affect how quickly they can get to mediation, excuse me.
Well, so the answer to that kind of depends on the type of case you bring. There are some types of cases that you bring that are required to mediate. For example, if you sue your homeowners association, you're required to mediate before you can go very far into the case at all. Some cases brought in federal court, for example, require immediate mediation. But assuming that you have the freedom to mediate when you want to, the answer is basically the same. Some cases are mediated early, some are mediated very late, somewhere in the middle. But just because you can mediate doesn't mean that it's a good idea to do it right away. And I realize that may be very tempting, to just say, well, let's just go mediate. But a mediate is a voluntary process, right? Only the two sides come together. The person, the mediator, we'll talk about who that is in a minute, they have no power. They can't make anybody do anything. If the case resolves at that point, just like any other time, it's because the parties agree, the plaintiff and the defendant or their representatives agree that this is the way the case will be resolved. So you can mediate at any time in most cases, but whether it's a good idea to mediate early really depends upon the facts of your case. And sometimes people will have different reasons for wanting to mediate on the defense side. Sometimes it's a genuine desire to avoid the expense of a lawsuit, or because they realize that they're not going to do very well in front of a jury. But many times it's also a stalling tactic. It's a delay tactic. Let's say you're in a business dispute, for example. Say you and your business partner have had a falling out, and he's locked you out of the building. He's locked you out of the bank accounts. You have access to nothing. And he says, let's go mediate. Well, in that time, he could dissipate all of your assets. He could take away everything. He could steal all the money. And you could go sue him for it, but maybe he files bankruptcy. So there's reasons why people on the defense side want to mediate that are not based upon a recognition of their responsibility and a genuine desire to settle the case. So that's kind of a long answer to a short question, but basically, you can mediate at any time. But you need to speak with your lawyer candidly about whether it's a good time to mediate your case. And your lawyer will have a sense of when's the good time. The other reason not to mediate too early is because you don't have your facts. Going in front of a mediator with half your facts or half of your evidence is not going to go well, because the mediator is just going to look at the case and say, well, you don't have a case, and you're not going to get very much money, and you're not going to get the resolution you want, and you will have wasted your time, and mediation costs money, so you'll have wasted your money as well.
Okay, so just so the audience understands, in lawsuits generally in California, is there some type of public policy? What role does mediation play? Is it something that's usually done in lawsuits or not done? Can you just give the audience a little preview of that?
Sure. The courts very much encourage mediation because courts are overbooked, like the airlines. On a given day, there may be 5 or 6 cases going to trial in front of the same judge. Well, that judge can only do one of them. So they count on 5 of those cases settling. And statistically, 95% of all cases, and sometimes more, will settle at some point. They'll either settle early or late or wherever, and only 5% actually go to trial. So mediation is one of the ways that many cases settle. Mediators are, they come from many different backgrounds. Some are lawyers, some are retired judges, some are just individuals who have special skills in negotiation. But one thing they all do is they gauge their success by how many cases they settle. So a mediator will tell you, oh, I have a 95% success rate, or I have an 85% success rate, meaning that they are able to settle 85% of the cases that they get. And if they have those kinds, if that's how they consider they gauge their success, well, then you know that when you go to mediation, there's going to be a lot of pressure and momentum to settling the case, assuming, like I said, it's the right time for the mediation. But the courts very much encourage mediation. And in fact, in most courts, you cannot get a trial date unless you engage in some sort of what we call alternative dispute resolution, ADR. Now, there are different ways that ADR can be accomplished, but the most common by far and the most successful is mediation.
Great. Okay, so let's talk about the mediation process itself. So for the members of our audience who really don't know what mediation is, we know there are 2 sides and then there's someone in the middle. Can you just describe for the audience the dynamics of mediation, what is set up for, and before it gets started, what is the goal of mediation? So
mediation and the mediator is the most important person in the mediation. That is not somebody who works for either side. They're in the middle. And it's their desire and their goal to settle the case. That's what they're there for. That's how they gauge their success, is how many cases they're given. Now, when a judge retires from the bench, from being a judge, many times they become mediators. And those folks are very valuable because they have seen thousands of cases, and they know how juries look at various cases. Plus, they are judges, they are lawyers, they know how to evaluate legal issues. So those types of mediators are probably the most effective. And when I say effective, that means you have the best chance of resolving your case in front of a retired judge. But there are very skilled mediators who were never judges. But no matter who you choose, the process is the same. You start with selecting the mediator. It has to be somebody both sides agree on. And then if the mediator works for a company, you've got to make a contract with the company. You get paid, the mediator gets paid for his or her time. And the sides split the cost of the mediator. So that's an expense. But many people are happy on both sides to mediate because you can save a lot of money that you would spend in the next phase, which is the trial phase, if you can settle the case. Even if it's not a perfect settlement. Even if it is not exactly what you wanted, it can be close enough that from the standpoint of choosing that resolution or going on to the expense of a trial, not just expense, but tremendous emotional and physical work that has to be done, that's the best way to do it.
Okay, so you did indicate that the mediator, the primary role of the mediator is to settle the case. And I believe you indicated that the mediator really doesn't care how it settles, but the mediator wants to have another notch in his or her belt that the case is settled, right? Now, I've had clients, who, they want to talk and they want to say certain things in the mediation. And can you talk about the dynamics? Like if you're an attorney and you're going into a mediation, what types of things do you say to your client? You tell them what to say or not to say before heading into that mediation, and why?
Okay. So first of all, I'll explain the process, which is in this day and age, many mediations are conducted remotely by Zoom. You, the client, are sitting in your home. Your lawyer is sitting in his or her office. The other lawyer is sitting in his or her office. And the person you sued might be sitting somewhere else. So it may be done by Zoom. And assuming it's that way, which is how most mediations are done this way, I'll use that as the example. But if you were actually meeting in person someplace, then it would be the same, except instead of virtual rooms, you have actual rooms. So usually the first thing that happens is I walk in with my client and I say, "Hi, I'm Steve Derby, it's my client. We're here for a mediation of this case." And then somebody directs us virtually into a room where it's just the two of us, or however many people are on our side. And then the same thing happens on the other side. They're directed to another room. And then the mediator pops in and out, like shuttle diplomacy, back and forth. And one of the big things I had to learn when I had to get used to this type of mediation was controlling those pops. Because you have to tell the mediator, "Hey, give me a heads up before you just walk into my room," figuratively, pop into my room, because my client might have been in the middle of telling me something that I don't want you to know. And this goes back to what Mr. Wade was saying about what is the mediator's goal. The mediator's goal is to settle the case. But like Mr. Wade said, and I've found this to be very true, is how that case settles is really not of any consequence to the mediator. It can settle very close to what you want, it can settle very close to what the other side wants, or it can settle somewhere in the middle. And there's really no way to tell how it's going to go. But you do know this, is you tell your lawyer everything. You do not tell the mediator everything, right? You leave that to your lawyer. The mediation is not the chance for you to plead your case. It's not like your deposition where you're asked questions and have to give answers. It's a completely confidential process. But mediators can't unhear things. If a mediator hears, for example, "Well, I would take this to settle my case."
That's it.
The mediator will say, and I will say to them, "No, you can't repeat that, Mr. Mediator." But now it's in his head, right? And it's going to be in his head all day. And you'll be amazed how many times you cannot get over that number, ever. Yeah. Because, so the thing to remember about mediation is it's not your deposition. It's not your chance to tell your case. You have a lawyer there. It doesn't mean you won't say anything, because part of the mediation process, good mediators always want to talk to the client just to sort of hear how they speak. Do they present themselves well? Because some clients, just to be honest, they don't present very well. And why does the mediator care about that? Well, because the mediator is trying to evaluate how that case is going to go at trial, either in front of a judge or a jury. And the plaintiff, remember we go back to, in the previous episode, we talked a lot about credibility. Well, credibility isn't just about telling the truth. It's about, are you believable? Do you tell a believable story? And one thing that a mediator always wants to do right at the beginning is ask you a few questions, sometimes about case facts, but more often just like, "How you doing today? Where are you living? What do you think about this whole process?" Some inane questions like that, just to see how you talk. But after that, what we call show and tell is over, you let your lawyer do the talking, always, and you never say a word in front of the mediator unless you're specifically told by your lawyer, you can answer that. That's very important, because the lawyer is working for you and nobody else in that process is.
Yeah, so you guys out there who are thinking you may want to go into a mediation by yourself, what we're trying to tell you is that's probably not a good idea. The mediation is a very, very, very comprehensive situation where there's a lot of gamesmanship to the mediation, right? I mean, I'm sure Mr. Derby can tell you, he's been at mediations where one side may start off by offering $2,000 and end up settling for $300,000. It's just how does typically when you're in mediation for someone who's going to be in mediation and they may be disheartened how it starts. Can you just explain the process of what we talk about as far as the offers and the demands that are being made throughout a mediation process?
Sure. So if you're on the plaintiff's side, I guarantee you the first thing you hear from the defense you will not like. You will not like it. And it's not just because they're trying to negotiate with you, it's because they're trying to once again see how can you handle disappointment? How tight, how committed are you to your case? So it's called lowballing. It's essentially giving you a number that's ridiculous. And the mediator will come back to you and say, okay, here's their first offer. It's ridiculous, but here's the first offer. And a lot of times what I do personally is I try to guess what the first offer is going to be with my client. And I say, I bet it's going to be this. And you'd be amazed how many times I don't hit it perfectly, but many times I'm very close. Because I know how they sort of think. And I know the process, especially when there's what I'll call institutional mediations, meaning you're going against somebody who's done mediation a lot. They know this process. And they know that you can become frustrated. And when you become frustrated, you want it to happen faster. But you have to have patience. It's a slow process. It many times takes more than one day. Many times, the sides will move together over a period of time, and then they'll sort of stop. And then the mediator will have to do something to start the process again. Or maybe it'll be the end of the day, and the mediator will say, okay, let's talk again in a week. The process is long. And so for you as the client, the most important thing you have to have is trust in your lawyer and patience with the process. Because your lawyer will tell you when you're wasting your time, because he's not there or she's not there to waste your time or your money. And as soon as the process is no longer fruitful, you're going to be leaving. But you have to trust that as long as your lawyer is sitting there telling you, okay, we should make another offer, we should lower our demand to this, we should change our tactics, whatever, you should follow it. Because lawyers, after 30 years plus of practice, have probably mediated 1,000 cases. And they've seen every sort of trick you could possibly come up with. And many lawyers are trained mediators like I am, who know even more about mediation because we get taught all those little tricks. And that's how I know, not just from my experience as a lawyer, that the mediator just wants the case to settle, somewhere. I know it from, that's what they teach us, is the most important thing is a settlement. Don't become overly, enamored. Don't become overly concerned or side with one or the other. Because at the end of the day, you're going to be somewhere in the middle. And if you go into the defense room pounding the table for the plaintiff, then what usually happens is the defense stops listening to you. Likewise, if you go into the plaintiff's room, into the room that you would be in, and the mediator is really mean, then you're going to stop listening to that person too. So the good mediators have the ability to be one thing in each room, but not too much of an advocate in either room. So the mediator, once again, is trying to resolve the case. And that's what they're there to do. However it resolves is not really important to them. That it resolves is the key. So you have to trust your lawyer, and you have to have patience because it's a long process. I've personally handled cases where at the start of the day, the demand was $2 million at the end, and the defense offer was $10,000. And at the end of the day, we did resolve that case. But it didn't resolve at $2 million, and did resolve at $10,000. It resolved somewhere in between. And the reason why it resolved it all was because my client trusted me and because my client had patience.
Okay. So the mediator, as you allude to, doesn't know much about the case at all. They come into the case and they're hired to settle the case. Can you talk about the importance of the lawyer's role in educating the mediator about the case, and what does that look like? What does that look like, and how does that happen?
Okay, so before you sit down in the mediator's office or wherever you're going to do the mediation, if you're going to do it by Zoom or whatever, your lawyer has already been working for you. Your lawyer has already filed what's called a mediation brief. It's not filed, it's given to the other side, typically, and to the mediator. So and what the other side tells the mediator in their brief, and what your lawyer says in his brief or her brief, that's all the mediator knows about the case, like Mr. Wade said. So it's very important that as your lawyer, we put the best facts. This is not an objective document. This is advocacy. This is when we put our best foot forward. If a fact could be seen two ways, we only say the way that helps you. And we don't necessarily talk about facts that don't help. We only talk about the facts that do. Now, there's some exceptions to that, going back to this issue of credibility. But for the most part, a mediation brief is where the lawyer begins to convince the mediator that you are right and that the other side is wrong. And if the lawyer does his or her job in that respect, you've already won the first phase of mediation, which is convince the mediator you are right.
Okay, so let's suppose the audience out there, they're lucky enough to have reached a settlement during mediation. What happens to the case then? How does the case conclude at that point?
All right, well, so every time a mediation is concluded, you definitely want to have a written document. Now, many times the settlement agreement is many pages. There's lots of legal and you can't put that together like that. It's got to be looked at carefully by your lawyer and by the other side's lawyer. But there is what they call a memorandum of agreement. And many of the companies that have lots of mediators, and some of the best mediators, have this one-page document. And sometimes you fill in, just handwrite it, and you sign it, and it has the key terms. It has, if there's money to be paid, how much is to be paid? If there's timing, like when is it to be paid? If there's something that has to happen before, like you have to give them a dismissal of the case, or you have to sign some longer document, that all gets put into a document. Because what you don't want to do is you don't want to reach a settlement at mediation and then have somebody change their mind. Because if they change their mind, it can probably be enforced, but it can only be enforced if a document was generated and signed before everybody left the mediation. Now, there's a process for that, and it hardly ever happens. When it usually happens, when mediations usually, as lawyers say, go sideways, is when they didn't do that. When it was 7:30 at night, everybody was tired. They'd been there since 9 in the morning, and everybody's just had it, including the lawyers, right? They've just had enough. And so they say, well, that's okay, we'll do it in the morning. And then overnight, somebody decides it's not a good deal for them, and they change their mind, and then the deal just goes away. So the important thing, if you get a deal that you have agreed to and that you want and that your lawyer has recommended, and you make sure that agreement is in writing. Not necessarily the full agreement that will cover every issue, but definitely something that your lawyer could use to enforce that agreement in court if the other side changes their mind.
Okay. So if you're unfortunate enough to reach an agreement during mediation, then you're going to have to go through the last phase of your case, which is the trial process. Steve, what percentage of civil cases do you think go to trial, by the way?
Less than 5%. It's not me who thinks it. That's the statistic in all the courts.
Okay.
95% of all cases settle. And one of the things a lawyer does is figure out whether, or through their skill, it settles very early in the case or very late in the case. Some cases just have to go all the way. And then you have what they call the settlement on the courthouse steps. Because even the day of your trial, the court is still trying to settle your case. Remember, I said that they're overbooked. They have more cases than they have judges. And so because of that, many times on the day of trial, a case will settle. The other reason is because there's various what they call pretrial procedures which happen the day of trial or the week before trial, which can change radically somebody's assessment, your lawyer's assessment of whether you will win or not. And that's a perfect time to resolve the case. Or it might go the other way, where the other side thought they had an argument and suddenly they don't. And that can be an opportunity to settle the case as well.
Okay, so for anyone out there who's thinking that you may want to represent yourself at trial, as we go through this process, you're going to be double thinking that, because in my opinion, it's the worst thing you could do is try to represent yourself at trial. So we don't have a lot of time here, but we've got to just generally go through the steps so they know what it entails if their case doesn't settle and they have to go through the trial process. So before they get to trial, and you alluded to it, what does an attorney normally have to do or have to submit to the trial just to have the judge know about the case before we even get to the trial?
All right. So a lawyer does 95% of the work before the trial begins. And the work is quite extensive. First thing is to assemble all of your evidence. You have to, in many courts, you have to actually have copies of every document you are going to use in trial. And many times you have to put them in binders. You have to have them with little stickers on them. Sometimes you have to have lists. Sometimes the two sides have to get together and have a meeting and come up with what they call a joint list of exhibits. Then you have to have all of your witnesses. You have to file a document with the court about what these witnesses are going to say. Many courts have, they call trial management schedules, where you actually have to say how long your trial is going to take. There is a huge number of documents you have to file. I'm not even talking about all the pretrial motions, which in some cases can take days, and in most cases will still take hours just to actually get those heard before the judge before you start. So it's a tremendous amount of work. 95% of it is done before a jury or the judge starts the case.
Wow. Okay, so you do all your pretrial submissions, like you said. You even do the pretrial motions, as you indicated to. And then if you're going to do a jury trial, briefly, can you tell us what is the jury selection process like?
So the jury selection process is not selection at all, it's elimination. Because you don't get to pick a jury. What you get to do is eliminate the jurors who you do not think can be fair to your case. You get to ask these folks questions. You'll know some information about their background, but you won't know that much. You can ask them certain questions. You can't ask them other kinds of questions. So a lot of it is just a feel. Whether you and your lawyer working together think that person could be fair. Not based just on their answers, but on their body language, on the things that they say, on the things they nod about that other jurors have said. And there's the jury elimination process is essentially eliminating everyone who you do not believe can be fair to your case. And hopefully what you're left with is the ones who can be fair.
Okay, so what is next? Can you tell the audience, what is an opening statement?
Opening statement is a story. It is the culmination of all the work that you and your lawyer have done since the day you first contacted your lawyer. It goes all the way back to that narrative, to that first statement. And many times it will look like that statement. Now, there's all sorts of thoughts and opinions about how an opening statement is told. If it's told from the point of view of the person you're representing or the other person, if you talk about what they did first versus what your client did, there's all this stuff. But essentially, an opening statement is just a speech that the lawyer gives after the jury is what we call impaneled, meaning they've been selected, they're in the box, and they've been given the oath of jurors, and they're sitting there with their notepads, and now they want to find out what this case is all about that they've decided or been forced, really, to sit and listen to. Okay,
so then, for the sake of time, then we know the trial starts, and the attorneys, they present their evidence. After that happens, what is a closing statement, and how important is that?
Well, the closing statement is the most important speech that your lawyer gives in the life of your case, assuming that you get that far. Because the closing statement is where your lawyer advocates on your behalf. The opening statement is about facts. The closing statement is about persuasion. Because the jury is going to get these things called jury instructions, statements of the law that are written for normal people, right? They don't have a lot of legalese to them. And if your lawyer does what your lawyer should be doing, they show the jury some of those key jury instructions, and they say, here is why we have proven our case, and here's what you need to check on, if it says yes or no, and I want you to check yes, I want to tell you why you should check yes. If it says no, and I want you to check no, I want to do that. And if there's an amount of money, I want to tell you what that amount of money will be. But the most important speech that I'll give in the life of any case is my closing argument.
Well, okay, well, I think you've heard it. This is the end of our segment here. We've gone through our first segment with regard to bringing in a case, and then today we spoke about mediation and an overview of the trial process. And we want to thank you for listening, and until next time.